Legal Latin maxims that could save your money, your life, and your future. You just signed a contract. You're excited. You think you've made the deal of a lifetime. 6 months later, a massive earthquake destroys the building you were supposed to lease. The other party sues you for breach of contract. You're looking at losing hundreds of thousands of dollars. But what if there's a Latin phrase that could get you out of this lawsuit completely? There is. And today, we're uncovering 10 legal maxims that most people have never heard of, but wealthy people, smart business owners, and savvy investors know by heart. These aren't just dusty legal sayings. These are the keys to protecting your money, your property, and your future. Let's begin. Maxim 1. AB. Initio. Here's a scenario based on how this maxim works. It's 2019. A young woman named Maya signs a marriage certificate in a courthouse. She's nervous, but happy. A month later, she discovers something devastating. The judge who performed the ceremony had no legal authority to do so. His license had been revoked weeks before the wedding. The marriage was never valid. Or imagine this. A company signs a major supplier agreement, but later discovers that the CEO who signed it was operating under a false power of attorney. The whole contract was fraudulent from the very beginning. This is where the maxim ab initio becomes absolutely crucial. Ab initio means from the beginning. It's a legal doctrine that says if something was defective at its inception, if something was wrong from day one, then it's void. Completely void, as if it never happened at all. In Indian contract law, this is absolutely critical. Courts will examine a contract from its very inception. If there was a defect in the process, if one party lacked capacity, if there was fraud, the entire contract can be declared void ab initio. Maxim 2. Actus. DEI. Nemine facit. Injuriam. Imagine a family that lost everything. In 2010, the Patel family owned a textile factory in Gujarat, India. They'd run it for 30 years. It was their life's work. They signed a long-term contract with a major buyer in the United States, guaranteeing delivery of fabric for the next 5 years. Then came the monsoon season. A freak flood, something that happens maybe once every 100 years, destroyed the entire factory. The machinery was destroyed, the raw materials were destroyed. Thousands of workers lost their jobs. The American buyer sued them for breach of contract. "You promised us fabric," they said. "We don't care about your flood. Pay us the damages." The Patel family was facing a lawsuit for millions of dollars because of something completely beyond their control. Then their lawyer invoked a maxim that would save them. Actus Dei nemine facit injuriam. The act of God does injury to no one. This maxim says something profound. You cannot be held liable for losses caused by natural events beyond human control. An earthquake, a tsunami, a hurricane, a flood, a pandemic. If an act of God destroys your ability to fulfill a contract, you're not at fault. The American company's lawsuit was dismissed. The Patel family wasn't forced to pay damages. The judge recognized that no person, no company, no entity should be punished for forces of nature they cannot control. But here's the modern twist. In 2020, when COVID-19 shut down the world, businesses across the globe tried to use Actus Dei to escape their contracts. Courts had to grapple with the question, is a pandemic an act of God? This is why understanding this maxim has become crucial in the modern world.
Because the law might protect you, or it might not, and you don't want to find out in a courtroom. Maxim 3. Actio personalis, moritur cum persona. This maxim has caused immense suffering, and I want to tell you why, because it affects you more than you know. Actio personalis moritur cum persona. A personal action dies with the person. Let me tell you a story. A woman named Eleanor was publicly defamed. A magazine published lies about her, damaging, hurtful lies that destroyed her reputation. She was preparing to sue for defamation when she suffered a sudden heart attack and died. Her family wanted to continue the lawsuit. They wanted justice for Eleanor. They wanted the magazine to pay for the damage it had done. But the courts said no. Because the claim was personal to Eleanor, because defamation is about damage to a person's reputation and dignity, the claim died when she died. This maxim says that certain personal claims don't survive the death of the person. If you're suing for defamation, you're suing for damage to your reputation. When you die, that damage doesn't pass to your children. The claim dies with you. Most jurisdictions now have survival statutes that allow certain claims to survive death. If you die from injuries caused by negligence, your family can often sue on your behalf. The law recognizes that this is fundamentally unfair. In the Eleanor example, modern defamation law also recognizes exceptions. If the defamation caused economic harm, if it cost Eleanor money, her estate might be able to recover those damages. Maxim 4, nemo dat quod non habet. No one can give what they do not have. Imagine. A man named David walks into a pawn shop in 2017. He sees a Rolex Submariner, $4,000, which is half its retail value. He's thrilled. He buys it, gets a receipt, walks out feeling like a winner. 8 months later, the police show up at his door. The watch was stolen in a burglary. The original owner wants it back. David protests. I bought it legally. I have a receipt. I paid good money. The court says, hand it over. You own nothing. Online marketplaces have made this problem epidemic. You cannot verify title on most goods bought from strangers online. The maxim is centuries old, but the exposure has never been higher. Maxim 5. Pari materia. Pari materia means of the same matter or subject. Here's the principle. Statutes that deal with the same subject should be interpreted consistently. Imagine a state has two laws. Law A says, no vehicle shall be parked on residential streets between the hours of 6 a.m. and 9 a.m. Law B says, all vehicles must be registered with the Department of Motor Vehicles. Now imagine there's a new law that says motorcycles are exempt from certain parking restrictions. The question is, does motorcycles in the new law mean the same thing as vehicles in the old laws? Using pari materia, a court would interpret motorcycles to mean the same thing in all three statutes. Consistency is key. Statutes are part of a larger code. They're meant to work together. If each statute used words inconsistently, the law would be chaos. One statute might define vehicle to include motorcycles, another might not. People wouldn't know where they stood. Pari materia ensures coherence. How many people are breaking laws because different statutes contradict each other, and they didn't know which one to follow? The answer is, more than you'd think. And courts use pari materia to sort it out, creating consistency from apparent contradiction. Maxim 6. Utres, magis, valeat, quam, period. Says that the thing may rather be preserved than destroyed. This is a principle of interpretation that says, when you're interpreting a law or a contract, choose the interpretation that preserves its validity and effectiveness rather than one that destroys it. Imagine a will that says, I leave my house to my son, John Smith, but there's a typo. It says John Smith instead. One interpretation. The will is invalid because the name doesn't match exactly. Another interpretation. The will is valid, but we need to figure out who John Smith actually refers to. It's probably John Smith, based on context. Utres magis valeat says, choose the second interpretation, preserve the validity of the will, honor the testator's intention. The alternative is absurd. A tiny typo destroys the entire will? That's not justice, that's not law, that's technicality, run amok.
Maxim 7. Damnum sine injuria. Here's one of the most frustrating legal principles you'll ever encounter. Damnum sine injuria. It means damage without legal injury. No remedy if there is loss, but no violation of a legal right. Imagine you own a small restaurant. Across the street, a major chain opens up with fancy advertising, great prices, and celebrity endorsements. Your business suffers. You lose customers. You lose money. You've suffered damage. Real, measurable financial loss. But can you sue? No. Because the chain didn't violate any legal right of yours. You don't have a legal right to have your competitors be unsuccessful. You don't have a legal right to your customers. You don't have a legal right to the same profit margins. You've experienced damnum sine injuria damage without legal injury. This maxim protects competition. It prevents people from suing every time they lose money. It says, you need to show not just that you've suffered loss, but that someone violated a legal right of yours. But here's the question. What if the competitor does something just barely legal? The answer, unfortunately, is you probably don't have a remedy. You've suffered damnum sine injuria. This is why understanding your legal rights is so crucial. You can't sue for every loss. You can only sue if someone violated a specific legal duty to you. Maxim 8. Pacta sunt servanda. Means agreements must be kept. This is the foundation of commercial law. This is why contracts matter. If agreements didn't have to be kept, commerce would collapse. You couldn't lend money because the borrower might not repay. You couldn't sell goods because the buyer might not pay. This maxim says, when you agree to something, the law will enforce it. Your promise is not just a moral obligation, it's a legal obligation. A company signs a contract to deliver goods by March 1st. They don't deliver. The buyer sues. The court enforces the contract. The company must either deliver the goods or pay damages. That enforcement is pacta sunt servanda in action. But here's what you need to understand. Not every promise is a contract. Not every agreement is enforceable. There are requirements. Consideration. Both sides must give something. Intent to be legally bound. Definiteness of terms. A casual promise to a friend isn't a contract. A vague agreement isn't a contract. An agreement for an illegal purpose isn't a contract. But when the requirements are met, pacta sunt servanda applies. Your agreement is law. This is why reading contracts before you sign them is absolutely critical. Maxim 9. Cavate emptor. Let the buyer beware. This is one of the most important maxims you'll ever encounter if you're buying anything: a car, a house, a business, a piece of art. It means the buyer must exercise due diligence. The buyer must inspect the goods. The buyer must ask questions. The buyer must not rely on the seller's promises. A man buys a used car from a private seller. The seller says, the engine is perfect, never had a problem. The buyer doesn't get an inspection. He doesn't have a mechanic look at it. He just assumes the seller is telling the truth. 2 weeks later, the engine seizes. The repairs cost $15,000. The buyer sues the seller for fraud. The court says, this is caveat emptor. You should have had a mechanic inspect the car. You should have asked more questions. You bought as is, and that's what you got. The buyer has no remedy. Caveat emptor puts the burden on the buyer. It says, don't trust the seller. Do your own due diligence. Inspect the goods yourself. Get expert opinions. Ask hard questions. But modern law has created important exceptions. Sellers have a duty to disclose material facts they know. If a seller knowingly misrepresents something, that's fraud. If goods are defective in ways the seller knew about and didn't disclose, the buyer has a remedy. But here's what you need to understand. The exceptions are limited. The default rule is still caveat emptor. The burden is still on you as the buyer. If you're buying anything significant, a house, a car, a business, you must inspect it thoroughly. Get professional inspections. Ask detailed questions. Verify everything the seller tells you. Document everything in writing. Get the agreement in writing with specific terms. This maxim teaches one crucial lesson. Never assume someone is being honest with you in a transaction. Never assume the goods are in the condition they appear to be. Never skip the inspection because you trust the seller. Due diligence is not just smart business, it's the law. These maxims form the skeleton of commercial law, contract law, and tort law. They protect you, they protect businesses, they protect civilization itself. But here's the question I want to leave you with. Which of these maxims do you think has had the biggest impact on your own life? Have you ever been protected by one of them? Have you ever been hurt by not knowing one of them? The more you understand these principles, the better you understand your rights, your obligations, and how to navigate a complex world. Thank you for watching. I'll see you in the next video. Stay informed, stay protected, stay wise.